Okay, this first question comes from Brittany, and the title is, How Can I Live with My Dad? The question is, I am 15 and my parents got divorced about 4 years ago. I have wanted to live with my dad the whole time, but my mom barely lets me see him. Is there any legal way I can live with my dad? I have spoken to him about it too, and he likes the idea, but my mom has threatened to call the police on him when I asked if I could live with him for a school semester.
Okay. Now,
what can I do?
does this have a familiar ring, Clarissa?
Oh, yes, I've heard that many times.
Well, and we'll give you a perspective on this question from a couple of different jurisdictions. I can tell you that from the state of Missouri, there's no age at which a child has an absolute right, short of emancipation, to declare where they're going to live. However, I can tell you that it's more like an upward sloping curve. The older a child is, all other things being equal, the more influential their opinion will be. And it, as a practical matter, if you have a 13, 14, 15-year-old who has good reasons for wanting to live with dad versus mom, then for the most part judges will sign off on that. But they don't have to. But generally they do. And let's face it, it's a practical matter when you have a 15-year-old kid that's as big or bigger than mom and dad, and they feel strongly that they want to live with one parent rather than the other. It's also a practical issue. I mean, how does the judge enforce anything contrary to what that child wants to do? So those considerations also are relevant. Tell me what you see in Indianapolis, for example, Clarissa.
Well, Indiana, the law is very similar to that in that the wishes of the child is always one of 8 considerations the court will look at. At age 14, they will put more weight on where the child wants to live, but it's never the only consideration. I mean, ultimately the court will make the determination based on the best interest of the child. But you're right, I think the older the child, the more likely the court is to side with the child's wishes. Usually the most difficult thing, at least in our practice, is getting the child's wishes before the court, which can be very difficult to do.
Right.
A lot of judges don't want to put the child in that position where they would have to testify in open court. Sometimes judges will talk to them in chambers. You can do custody evaluations and things like that. But it's very difficult if that's the only thing out there is the child's wishes to change custody without some other change. I think based on the question you gave, there's some other issues as far as mom not allowing daughter to have a relationship with father. I think that's something that her father could, as a first step, try to work on in making sure
that could be the thing that she hangs her hat on. For example, if there needs to be a basis other than simply the child's made this decision, they want to do something different. And we do see that, and as Clarissa suggests, I think in virtually any jurisdiction, or let's say the majority of jurisdictions, you're going to need more than that, some changed circumstance. But typically underlying that, if you peel back a layer or two, you find that there are things going on that do constitute that. One thing I should mention is there are jurisdictions in which we have offices where there's an age at which there's a presumptive right for the child to state where they want to live and for that to be the outcome of the case. But it's a presumption, as I recall, which means it's subject to being rebutted. I think that Georgia either gives an absolute right at age 12 or a presumption, and that's not uncommon in several states. Now, Clarissa raises a good point. To the extent that there's alienation going on, other things, then you probably have something to call the court's attention to. I would also mention this. While I'm not a fan of guardians ad litem generally, and I've talked about that at length and we have on this show, still, they have their place where they're very useful, where they're essential, in fact. And a case such as this could be it. It may be that dad, could file an action, ask for the appointment of a guardian ad litem, and that's the sort of back door sometimes by which you can get what a child wants in front of the judge. But as Clarissa points out, a lot of judges are very reluctant to have kids come in and testify. We see that in the movies a lot, where kids, are testifying the stand, and we think, gee, how awful that is. And it's often in this heart-rending setting. And the reality is that is a bad thing, and a lot of judges don't want to see it happen where kids testify in open court. So those who do have the child testify are much more likely to do it in chambers. It's called an in-camera interview. Did you see that a lot, Heather, in St. Louis County?
I've seen it back and forth, to be honest with you. I think in the practical world, in St. Louis County and St. Louis City, the age of the child comes into play as to what makes common sense. I always tell my clients, the older the child gets, the less the court has jurisdiction to control where they go. Obviously, sometimes where the child lives is important to one parent or another for child support reasons. But the wishes of the child, the older they get, the court has less ability to force a child to go to one place or another. So the older the child gets, I've had judges like Judge Frawley tell me, you know, Dad, you're lucky if you get your one night a week and every other weekend, because she's in high school, she's going to go do things. She may not be there all that time, and there's simply nothing I can do, and vice versa with mothers. You know, I've had mothers that we've been, you know, representing the father, and the mother comes in and says, my child won't come visit me, and that's Dad's fault.
Yeah. And you know, and I don't want to linger too long on this issue, but you're right, Heather, and without mentioning any names of judges, we do see some judges who tend to, in my opinion, prematurely sort of throw up their hands and say, gee, this child's older now, doesn't want to go, what are you to do? And the reality is that that's fine when that child's coming home to mom's house every night.
Absolutely.
And this is an example of the sort of bias that exists in the system is, you know, judges are all too quick to simply throw their hands up and say, look, this child is 14 years old, and I'm not going to make them. They have things going on in their life, end of discussion. I suspect if the shoe were on the other foot and mom was never seeing their child, is it reasonable when you have a teenager to not see your child at all? Is that what having a teenager means? And the answer is no.
Absolutely.
And it's a non-issue when that child's coming home to your house every night. But when you're dad, you could potentially not see the child at all. And it's certainly not acceptable to not send a check. I mean, you know, the check, we know, that's very doable. And as a matter of fact, even when it's not doable, maybe he should sit in jail for a while and think about how to produce money from thin air. Am I on a rant here, Clarissa?
No. I think you're definitely speaking the truth when it comes to kind of the bias that is out there. I know Indiana, you know, has some. You know, we have a set of parenting time guidelines, and there's a lot of commentary about, you know, visitation with teenagers, and you have to be flexible, and you have to do this and that. But
right, and we agree with that, and I think that most of our attorneys, we line them up. They'd say, of course, there has to be some flexibility and blah blah blah, but it's so frustrating to have dads come in who say they haven't seen their child in a month,
Absolutely.
and then you file a motion for contempt. And the court won't find mom in contempt. She says that she should be the primary custodial parent. She fought a war for that, presumably, and won it. So she's awarded primary custody. Having won the war, she announces, well, I can't control this child. What do you think I am, a magician or something? And Dad, meanwhile, is standing there saying, well, I bet I can. And you know, these discipline issues, you know, it's not uncommon to have dads saying, look, you know, I would have more authority. I'm willing to use appropriate discipline, but I'm willing to, you know, to exercise my authority and see to it that the child minds me, or that the child does their homework, or the child does those things that the child needs to do. And it's a frustrating situation when the very thing that Dad's complaining about is used to beat him over the head with and say that mom isn't in contempt because she can't control the child.
Right.
Anyway, we won't rant further about this, but Heather hit on an issue that we deal with all the time. Should we do one more question real quick? Do we have another one up?
Sure.